It was just past midnight on New Year's Day 2026. While most of the world was still clinking glasses and watching the final embers of fireworks, a very different kind of countdown was finishing at the arrivals gate. I noticed this story shared by a man who had spent the last 3 years navigating the labyrinth of U.S. immigration to bring his wife home. He was standing there with a bouquet of wilting roses, checking a flight tracker that promised her landing at 12:15 a.m. To him, this wasn't just a new year. It was the year one of his family finally being whole. But as the clock struck 12:01 a.m., the digital ink on a new piece of paper, Presidential Proclamation 1998, became the law of the land. What's so striking about this moment isn't just the suddenness, but the collapse of a long-standing, almost sacred assumption. For decades, there was this unwritten understanding in the world of border policy. No matter how high the walls got, immediate family was the red line the government wouldn't cross. The bond between a husband and wife or parent and child was the final exemption, the one piece of humanity the bureaucracy spared. But this morning, that safety net was pulled away. With a single stroke of a pen, the administration didn't just tighten the borders. They fundamentally rewired how the U.S. views the immediate relative. The official rhetoric speaks of protecting national security and rigorous background checks for 19 specific nations, ranging from Afghanistan to Myanmar. It's all presented as a cold, logical necessity for a safer border. Yet looking at the silent confusion in those airport terminals, you see a different reality. The logic of "it's for your own safety" starts to feel very different when it's the reason a spouse is turned back at the final hurdle. That instantaneous shift from a country that prioritizes family reunification to one that views a marriage certificate as a potential security threat, it raises a question that goes far beyond simple politics. It makes you wonder, when we redefine security to include the exclusion of a person's own family, what exactly is it that we are trying to save? That opening story it really sets a powerful and, frankly, a difficult scene. Our mission today is driven by that exact moment, that abrupt policy shift.
It really is.
We're going to do a deep dive into Presidential Proclamation 1998 and this whole enhanced vetting apparatus that came with it. Yeah. We need to unpack the legal architecture that allowed this to happen.
Right. How the immediate relative exemption could just collapse.
Exactly. And the highly invasive technology that's driving this new screening, and then the massive geopolitical fallout of closing America's doors to almost 40 nations, with 19 of them facing a near total ban.
And it's so essential that we view this policy not as some simple update, but as the culmination of an intense, years-long administrative shift.
A shift toward what?
Toward the securitization of legal immigration.
Right.
For generations. I mean, family reunification, especially for immediate relatives, spouses, minor children of U.S. citizens, it was shielded.
Right, it was insulated.
Completely insulated from annual caps, from broad geopolitical restrictions, because the legal system recognized the fundamental right of a citizen to family life. This 2026 proclamation just transforms that foundational principle.
It goes from a priority to what?
To a secondary consideration, one that is systematically and legally overridden by these new national security mandates.
Okay, let's unpack the mechanics of this legal earthquake right away. You mentioned that sacred assumption in the opening, the whole idea that family reunification was the red line. What specifically gave that safety net its strength historically? And what was the exact stroke of the pen that just removed it overnight for these countries?
Well, the strength really came from the fundamental structure of U.S. immigration law itself. When we talk about immediate relatives, we're mostly talking about the IR-1 and CR-1 visas.
The spouses of U.S. citizens.
Or spouses, yes. And these are what we call numerically exempt categories.
Meaning no annual limit.
No annual limit. And that's hugely significant. It means that historically, once you proved you were eligible, the path was guaranteed. You avoided the decades-long queues that other family categories face.
So there was a protected lane, so to speak.
A protected lane, exactly. And that safety net, the thing that protected them, even during, earlier periods of heightened security, like the first travel bans, it was an explicit exception written right into the legal framework.
So this administration didn't just add a new layer of complexity like more paperwork?
Oh, no. This was structural.
They removed the entire class of exception.
Precisely. Presidential Proclamation 1999, it superseded and dramatically expanded the one that came before it, 1949. And its key action was to explicitly eliminate several of these crucial categorical exceptions.
And at the top of that list was family.
At the very top. The removal of protection for immediate family immigrant visas. This covers the IR-1 CR-1 for spouses, the IR-2 CR-2 for minor children, even the IR-5 for parents of adult citizens.
And it didn't stop there, did it?
No. It also extended to adoption visas, the IR3, IR4, IH3, IH4 categories, which are, they're fundamental to international humanitarian efforts, all gone for these countries.
That just confirms the devastating reality for the man waiting at the airport. It means for the nations targeted by this full suspension, the promise that, if you marry an American citizen, you will eventually be reunited.
That promise is gone.
Because it's just not true anymore.
That is the new harsh reality. You have to consider the story of, say, Min Za in Yangon, Myanmar. Myanmar is on the full suspension list.
Okay.
He was deep into the process for his IR1 visa. Married to his U.S. citizen wife for 2 years, done the interviews, submitted the paperwork. Under the old system, his case was a clear priority.
Because family reunification had that legal weight.
It had weight. The moment the calendar flipped to January 1st, 2026, his file immediately transitioned from being in an active priority queue.
To what?
To effectively suspended, indefinitely stalled.
Wow.
And his wife's realization, that moment where she understood that the fundamental legal architecture governing their entire future had been replaced overnight by these unilateral national security mandates, that is the core outcome of PP 1998.
So the legal status he had, this protected path,
it vanished. It just disappeared, leaving only this near impossible route of trying to get an individualized exception, which we can get into that later. It's not much of a route.
And it's important to note, this shift wasn't presented as a punishment, was it? It was framed as an administrative necessity.
A mandate.
Right, a mandate aimed at strengthening security. It's a crucial distinction in the rhetoric.
It is. It frames the rigorous vetting, this need for absolute information, as something that simply outweighs the established humanitarian tradition.
So it's a functional redefinition of what matters most.
Absolutely. The administration's stated justification focuses on countries that are either, in their words, unable or unwilling to share critical biometric or identity information.
Which makes rigorous background checks impossible in their view.
Correct. Therefore, the immediate relative bond, which was once a shield, is now just another category of application that's subject to this higher security standard.
And if the standard can't be met because the country is in chaos or just won't cooperate,
then the application category itself becomes irrelevant. It doesn't matter if you're a spouse or a tourist. You're just an applicant from a non-compliant country.
Cool. Let's clarify exactly which nations are facing this absolute closure. The full list of 19 countries is, it's a lot to absorb just hearing it. How can we categorize this full suspension list? Are there clear geopolitical threads linking these nations?
It's a diverse list, but yes, we can see some patterns. It represents countries the U.S. government has deemed to be in full non-compliance with their new vetting baseline, or they're nations with such severely compromised stability that reliable information gathering is just impossible.
This is the full suspension of visa issuance list.
That's the one. And for clarity, you can really break the 19 nations into 3 broad categories.
Okay.
First, you have your significant zones of conflict or, deep instability. That's Afghanistan, Syria, Yemen, Libya, Somalia, South Sudan, and Haiti.
The ones you'd probably expect.
Right. Second, you have regimes or nations with protracted diplomatic tension with the U.S. or with severe human rights concerns. That's Iran, Eritrea, and the Republic of the Congo.
Okay, that makes sense. What's the third group?
The third group is a large cluster of nations, mostly from the Sahel region of Africa and Southeast Asia, which have been cited for critical deficiencies in identity management and information sharing.
So a more technical reason?
A more technical justification, yes.
Yeah.
This includes Burkina Faso, Chad, Equatorial Guinea, Laos, Mali, Myanmar, Burma, Niger, and Sierra Leone. And Sudan is also on this list.
So the ban really encompasses everything from active war zones to nations that are just categorized as failing to meet a new technological standard for data sharing.
Exactly.
And this full suspension, it applies to virtually all visa categories, immigrant and non-immigrant.
That's correct. It's a blanket suspension. It applies across the board, barring those few extremely narrow exceptions we should detail.
And there was another expansion too, right? It wasn't just based on nationality.
A very significant one. The proclamation also applies this full suspension to any individual traveling on any travel documents issued or endorsed by the Palestinian Authority.
So that moves beyond a traditional geographical or citizenship ban.
It does. It becomes a ban based on the origin of your travel document, which adds a major restriction for a largely stateless population.
Given that near total suspension, the routes left for people from these 19 nations, they must be vanishingly small. Who, if anyone, still has a guaranteed legal path to the U.S.
The door is barely cracked open, and really only for purposes the administration deems critically important to U.S. government functions, or certain very specific humanitarian cases that are recognized as an exception to the rule.
So what are these exceptions?
Okay, the few narrow exceptions that remain are, first, certain diplomatic and official visas.
Makes sense. Government-to-government stuff has to continue.
Right, basic functions. Second, dual nationals who can apply using a passport from a non-restricted country.
Which is a technicality. It's not a solution for the vast majority of people.
Not at all. Third, and this is a very specific carve-out, immigrant visas for ethnic and religious minorities facing persecution in Iran.
So a targeted humanitarian loophole.
Highly targeted, yes, for vulnerable groups often targeted by the Iranian regime. And finally, there are special immigrant visas, SIVs, for certain U.S. government employees.
Okay, let's pause on that last point, the SIVs.
Yeah.
When you read out the list of fully banned nations, Afghanistan was at the top. Did this proclamation specifically target or restrict those Afghans who worked for the U.S. military, the people who, have the clearest moral claim to entry?
This is one of the most significant and, frankly, restrictive details of PP 1998.
I can imagine.
While SIVs for U.S. government employees in general were kept as an exception, the proclamation explicitly. It carved out and eliminated the exception for Afghan special immigrant visas.
So they specifically removed the protection for Afghans who helped the U.S.?
Yes. It's a profound move. It signals an unprecedented tightening of even the most, you could argue, morally obligatory pathways for entry. It effectively abandons a long-standing commitment to those individuals who provided crucial support to U.S. operations.
And for the thousands of Afghans who were already waiting in that SIV pipeline.
That single stroke of the pen just compounded their risk. It removed their protected status and forced them into the exact same suspended category as everyone else from a fully banned nation.
So to sum up this first part, the legal default for spouses, children, even our closest government allies from 19 countries, went from an established protected category to immediate suspension.
And the only path forward is an extremely difficult, almost impossible individualized appeal.
It's an immediate seismic legal shift.
And to really grasp how the administration had the legal tools to enact something like PP 1998 so quickly and so comprehensively, you have to look back.
At the president.
Exactly. You have to look at the framework that has been building over the last decade. This policy didn't just emerge from a vacuum. It's an intensification of a legal trajectory established years ago.
Okay, so let's trace that policy lineage. We often talk about the travel ban as this one generic thing, but there have been several distinct administrative actions. How did those earlier policy decisions lay the groundwork for this massive 2026 expansion?
The precedent really begins back in 2017 with the initial executive order 13769.
Right, the first one, that was chaotic.
It was legally tumultuous, yes. It targeted 7 countries: Iran, Iraq, Libya, Somalia, Sudan, Syria, and Yemen. Its rapid implementation and all the subsequent legal challenges. It showed the executive branch that broad restrictions were possible, but they needed a more detailed, more security-focused justification.
So they learned from the court battles.
They did, and that led to the revised and much more enduring framework. Presidential Proclamation 9645 in September of 2017.
The third version.
The third version, yes. And it shifted the criteria. It removed Sudan from the list, but it strategically added North Korea and Venezuela.
Which didn't really fit the original narrative.
They didn't, but they were justified on the grounds of security and, crucially, a lack of information sharing. And this established the key mechanism. The administration gets to determine the security deficiencies of a country, and that deficiency becomes the legal basis for exclusion.
And that framework expanded again before this 2026 proclamation,
right,
signaling a clear policy of just successive tightening.
Oh, yes. The policy continued to widen its net. In January 2020, you had Presidential Proclamation 9983.
Okay.
That one added 6 more countries: Nigeria, Myanmar, Eritrea, Kyrgyzstan, Sudan was back on, and Tanzania.
And what was the focus there?
Crucially, the 2020 expansion largely targeted immigrant and diversity visas. It was focused on cutting off the pathways for long-term entry and resettlement.
So it was setting a precedent.
A huge one. It showed that even functional democracies like Nigeria could be restricted based solely on so-called information sharing failures, rather than any kind of direct security threat.
Which brings us to 2026, where the restrictions aren't just this full ban on 19 countries. There's also this secondary list, the partial suspension list, which affects many, many more nations.
That is the critical distinction. It's not an all-or-nothing system.
Right.
If the 19 fully suspended countries are the red list, the nations in full noncompliance, you have the separate, large partial suspension list of 20 countries, and they are subject to major restrictions across key visa categories.
And who is on that list?
It includes nations like Angola, Nigeria, Senegal, Tanzania, Zimbabwe, Cuba, Venezuela, and even Tonga. Additionally, Turkmenistan is named separately with a partial suspension that specifically impacts all of its immigrant visas.
So what does partial suspension actually mean on a practical level? For an applicant from a country like Nigeria or Tanzania, what specific routes are not closed to them?
Well, the partial suspension is pretty comprehensive. It targets the very pathways that facilitate exchange, business, and long-term residency.
Okay.
So for nationals of these 20 countries, the suspension impacts three main areas. First, all immigrant visas.
So no more long-term path to the U.S.
Exactly. It blocks standard family preference categories for siblings, adult children, and all employment-based visas. The path to a green card is effectively closed.
What else?
Second, non-immigrant visitor visas, B1, B2.
Which are essential for tourism, business meetings, any short-term engagement.
Absolutely. And third, student and exchange visitor visas, FMJ.
Wow, so that hits education and cultural exchange.
Hard. It affects students, academic researchers, cultural representatives. In essence, if you're a rising professional in Lagos or a student in Dar es Salaam, this policy just drastically reduces your avenues for legal entry, even if you weren't covered by the previous full bans.
So it's a significant administrative downgrade.
It is. It limits both economic and academic engagement with the U.S. on a massive scale.
So if the family categories are gone for 19 countries, and this huge list of another 20 countries is partially suspended, the only real hope left for someone with a compelling reason to travel, say, critical medical treatment or a dying relative, is this individualized exception.
Right.
What is that mechanism and how feasible is it really?
The individualized mechanism is the national interest exception, or NIE. And the administration wisely maintained this escape clause because, completely closing the door would likely run into some serious legal challenges related to due process.
That legal safety valve.
On paper, yes. The NIE allows the Secretary of State, the Secretary of Homeland Security, or the Attorney General to grant a visa on a case-by-case basis.
But the bar must be incredibly high.
Very high. The determination has to be coordinated across departments, and it must advance a critical U.S. national interest. We're talking about things like critical infrastructure work, a major diplomatic goal, or a key law enforcement function, not personal hardship.
The rhetoric of the NIE, it sounds like a humane option. But the historical data from the previous travel bans suggests this is an incredibly difficult path. What does history tell us about the success rate?
The historical reality is it's crucial for context here. We can look at the track record of the waiver mechanism under the earlier policy, PP 9645, which also allowed for these individualized exceptions based on undue hardship.
And the numbers?
The data is damning. Through April 2018, only 2% of applicants were granted waivers.
2%?
2%. That translates to just 579 approved cases out of more than 33,000 applications.
That's staggering.
It illustrates the immense bureaucratic friction and the subjectivity that's inherent in this NIE process. When you remove that categorical family exemption, every single application is forced into this system, the NIE, that historically has a near impenetrable acceptance rate.
So the burden of proof just shifts completely.
It shifts entirely. You go from having to prove you're eligible for protected status to having to prove that the United States needs you to enter. And that's a far higher and much more subjective standard.
It sounds like the legal system has been engineered to create the appearance of a path forward.
While the administrative process ensures that it operates in practice as a near total denial system.
Humane on paper,
Yeah.
built for exclusion in reality.
Yeah.
We've spent a lot of time on the removal of the family path, the expansion of the ban lists. Now I want to shift to the how, because this entire policy is justified by the implementation of enhanced vetting.
Right.
The administration presents this as a strategic imperative. We can only open the door if we are 100% sure of who is walking through it.
And this is the core engine of the 2026 policy, PP 1998, and the underlying directive, Executive Order 14161, which was signed a year earlier in January 2025. They are entirely focused on implementing what they call rigorous background checks and radically strengthening screening procedures for all foreign nationals.
So this was planned well in advance.
Oh, yes. EO 12161 mandated that federal agencies spend 60 days reviewing and implementing these updates. The philosophy is simple and it's uncompromising.
Which is?
If a country cannot or will not provide the specific types of data the U.S. government now deems necessary, specifically detailed biometrics and digital metadata, it is automatically classified as a high-risk failure state.
And its citizens are suspended.
Automatically.
It's moved so far beyond traditional verification. It's no longer about checking criminal records or confirming dates of birth.
No.
It's about leveraging technology to perform a predictive analysis on an individual's future intentions, their risk potential.
That is precisely why many people are calling it digital interrogation. The anecdote of Omar, an engineer applying for a specialized non-immigrant visa from Kabul, a fully banned nation, it just perfectly illustrates the new standard.
Omar's requirement for 10 years of his digital footprint.
Yeah.
That seems almost impossible for anyone, let alone someone trying to navigate the instability in Afghanistan. What exactly are they asking applicants to surrender?
It goes so far beyond simply handing over your Facebook or your X handle.
It's not just social media.
No, they are demanding highly invasive, comprehensive data. Applicants have to submit IP addresses associated with every device they've used.
Every device.
Every device. Metadata from private communications, details of family group chats on encrypted platforms like WhatsApp, and a full decade of activity on professional platforms like LinkedIn. The goal is to build a complete social and digital profile of you.
How does the U.S. Vetting Center even process that tsunami of information? How does a background check evolve from just reviewing data to predictive surveillance?
It's driven entirely by new technological infrastructure. Omar noted that the vetting center uses AI-driven deep dives.
Okay, what does that mean?
It means the system uses sophisticated natural language processing, or NLP, to analyze the sentiment and the content of all your digital communications. It's looking for specific language patterns, shifts in your tone over time, or discussions that flag ideological divergence.
So it's reading everything and judging it.
And more threateningly, the system performs extensive link analysis.
Link analysis.
It doesn't just look at what Omar said. It looks at who he talked to, where he transferred money, and whether his contacts connect, maybe 3 or 4 degrees of separation removed, to individuals on undisclosed government watch lists.
So a comment he made on a news article 5 years ago.
It's not just a data point. It's a variable in an algorithm that's designed to calculate his final risk score.
And all of this is cross-referenced with hard biometric data, right? We're talking iris scans and DNA. That turns the screening into something fundamentally physical, unchangeable.
Absolutely. The system is designed for maximum redundancy. The AI-driven digital profile of you is cross-referenced with your physical biometric dataful iris scans and DNA against these massive undisclosed government databases.
To put this intensity in context, this didn't just appear in 2026. This level of data collection has been a long-term goal for U.S. security agencies.
It has been the explicit trajectory for years. You can trace this right back to the 2019 announcement from the Department of Homeland Security. They positively stepped up their biometric data collection then.
I remember that.
At that time, they were implementing a DNA testing pilot program and initiating the fingerprinting of children under the age of 14.
Moves that were highly controversial at the time.
Very. And the 2026 process represents the full fulfillment of that trajectory. The DNA checks and the iris scans that were once just discussed as pilot programs are now fully integrated and mandatory elements of the high-level vetting procedure for anyone from these high-risk countries.
The entire background check process has been fully weaponized.
Into a function of predictive surveillance, yes.
I think we need to be crystal clear for everyone listening who exactly fell under the shadow of this new proclamation. Was it everyone who had applied but hadn't entered yet, or just people who were starting the process?
The criteria for applicability are sharp and they are unforgiving. Presidential Proclamation 1998 specified that it applied to 1. Foreign nationals who were physically outside the United States on January 1st, 2026.
Okay.
And 2. Foreign nationals who did not possess a valid U.S. visa as of 12:01 a.m. EST on that date.
That sudden cutoff. That's why the man waiting for his wife at the airport and Minza, they were directly impacted. Because their loved ones were physically outside the U.S., and their visa process was contingent on the old rules.
Precisely. Anyone who had a visa issued before that effective date was generally safe. Those visas were not revoked. But for the thousands who had already submitted their applications, often years prior,
their fate was sealed by the calendar turning.
Regardless of how much investment or effort they had already expended, it was an instantaneous administrative execution.
So the conclusion here is that the U.S. government has now established a new legal standard, and it's invested in the technological capacity to vet people down to their DNA and their decade-old digital traces.
And if you or your country cannot satisfy that level of security rigor, a standard that very few unstable nations could ever meet, the door defaults to closure.
We've explored the legal mechanism and the technological apparatus. Now we have to look at the long-term non-security consequences. When the U.S. draws these invisible borders so sharply, especially impacting 39 nations in total, what is the cost of that exclusion?
Yeah.
In terms of global influence, diplomacy, the economy.
I think the primary cost is the erosion of American soft power.
Right.
For decades, the ability of the U.S. to attract the world's most promising students, entrepreneurs, and those seeking refuge, it served as a powerful diplomatic tool. The American visa was a symbolic entry ticket to the promise of Western opportunity.
And now that ticket is gone for millions of people.
It is. For pro-Western students, scientists, professionals in those 19 full-buy nations, I mean, think of aspiring engineers in Burkina Faso or academics in Syria, the U.S. visa represented a crucial avenue for advancement.
A way out and a way up.
Exactly. The proclamation, by fully suspending almost all categories of entry, doesn't just block a route. It sends a clear, powerful geopolitical message of permanent exclusion.
And what does that message translate into diplomatically for those 19 nations?
It translates into profound damage to bilateral relations and strategic influence. The proclamation effectively tells these nations that, regardless of any current government reforms or future cooperation efforts, they are structurally designated as high risk.
With no clear path back.
No clear or realistic path back to normalized engagement, trade, or cultural exchange. When the U.S. dismantles the bridge of legal immigration, it inevitably damages its capacity to influence future leaders and project its democratic values globally.
And this has immediate effects, right? Not just long-term hypotheticals.
Oh, immediate measurable effects on global education and talent mobility. The sources identified this as leading to a phenomenon of shadow migration.
Explain that. If the U.S. is no longer a viable destination for global talent, where does that talent pivot to? What's the strategic loss for the U.S.?
Well, the talent doesn't just disappear. It simply migrates to competing geopolitical powers who are more than willing to accept them.
Okay.
We are already seeing specific, actionable examples of this in educational sectors across West Africa. Student organizations that used to specialize in preparing students for the TOEFL and ESSET exams geared toward U.S. universities are now reportedly pivoting their entire curricula.
They're teaching something else.
They're actively looking toward universities in Moscow or increasingly Beijing, where educational pathways and streamlined student visas remain wide open.
And those rival systems are capitalizing on this.
Actively. They're capitalizing on the administrative vacuum created by PP 10998 by offering quicker, less invasive entry paths and in some cases guaranteed employment upon graduation.
That is the strategic cost in high definition, isn't it? It's not just losing a potential student.
No.
It's ceding the crucial long-term opportunity to cultivate a future leader who holds an affinity for American institutions and democratic principles.
That's it exactly. You secure the physical perimeter, but you forfeit the diplomatic influence. The U.S. ceases to be the destination of choice. You're driving intellectual and professional capital, the scientists, the entrepreneurs, the culturally aware, directly into the systems of your geopolitical rivals.
Undermining the very idea of America as the world's magnet for opportunity.
It fundamentally undermines it.
Beyond the diplomatic and soft power implications, we have to address the hard economic costs. Does restricting legal immigration, even from unstable areas, have a demonstrable impact on the U.S. economy as a whole?
The economic consequences are significant, they're measurable, and they are long-term. Even before this 2026 proclamation, economists consistently warned that broad immigration restrictions act as a major headwind against economic growth.
Why is that?
Because immigration is a core, sustained component of labor force expansion and innovation. Economic vitality is driven largely by two factors: the growth of the labor force and the productivity of that labor force.
And restricting legal immigration hurts both.
It hurts both. Immigrants historically start companies at twice the rate of native-born citizens, and the data shows that nearly half of the companies in the Fortune 500 were founded by immigrants or their children. When you cut off the flow of new talent, you are choking a massive engine of innovation and productivity.
Let's detail that financial warning. How large of a financial hit are we talking about if these restrictions keep the flow of legal immigration significantly depressed?
The numbers are stark, and they're based on prior administration analysis. If annual legal immigration were to fall significantly, for example, from the historical average of around 1 million per year down to a much lower figure, say 200,000.
Yeah.
The research by Moody's Analytics warned that the U.S. gross domestic product could be lower by as much as $1 trillion within a decade.
$1 trillion.
$1 trillion. This is a profound long-term fiscal cost that counterbalances any immediate perceived security gain.
And the economic logic is simple.
Very simple. Fewer legal workers mean a shrinking tax base and fewer contributions to crucial entitlement programs like Social Security and Medicare, which are all funded by payroll taxes.
So the policy, which is justified as an immediate security protection,
it inadvertently carries a massive long-term fiscal debt driven by lost talent and stunted economic growth. It is a fundamental trade-off of fiscal health for enhanced border control.
So, in summary, the U.S. is trading immediate, if administratively burdensome, security for immense long-term geopolitical influence and economic stability.
The system has redefined security not just as a defensive posture, but as a deliberate act of economic and diplomatic retreat.
This deep dive into Presidential Proclamation 1998 reveals a fascinating and, frankly, a disturbing convergence of legal policy and technological capability. We've really covered three major shifts that fundamentally redefine the landscape of U.S. immigration. First, we analyzed the absolute legal closure of the immediate relative path, the IR1, the CR1, adoption visas for 19 nations, a path that was historically viewed as the final humanitarian red line.
And those personal accounts, like Min Zha and his American wife, they just highlight the immense human cost of replacing that long-standing categorical exception with these stringent national security mandates.
And second, we examined the unprecedented level of vetting now required. The administration's strategic imperative is to prioritize systemic control, which relies on the sophisticated AI-driven digital interrogation.
A system that requires applicants like Omar to surrender a decade of granular digital and biometric data, effectively transforming the background check into a comprehensive predictive surveillance tool.
And third, we quantified the significant strategic cost. By establishing these hard, invisible borders against 39 countries, the U.S. risks eroding its vital, soft diplomatic power.
And accelerating that shadow migration of talent and potential allies toward competing powers like Russia and China.
And incurring a measurable long-term economic penalty in the form of reduced GDP growth.
And that's why this proclamation is not merely a piece of updated regulation. It is a profound philosophical statement. The bureaucracy has permanently redefined security, prioritizing administrative control and algorithmic risk assessment over established humanitarian traditions. This shift creates a system so rigorous that the traditional American commitment to family reunification is functionally replaced by near impenetrability. The quiet reality is that this new administrative architecture, effective on a cold New Year's morning, represents a permanent state change. The substitution of family reunification and soft diplomatic power with stringent data-first exclusion, which will reshape international relations and the global flow of talent for decades to come.